My name is Daren Rasmussen, and it's a pleasure to do this presentation. Let me go ahead and share screen. All right, this is status of Utah stream alterations. Why we need regulation, why there's regulation, and what is needed for stream alteration. I've worked for the State of Utah Department of Natural Resources, Division of Water Rights, in stream alterations and dam safety for over 20 years. So just a little bit about who I work for and stream alterations, how they came to be. The Office of the State Engineer was created quite a while ago in 1897, and the State Engineer is the Chief Water Rights Administrative Officer. All the waters in Utah are public property, and the State Engineer is tasked to oversee the state's water rights, including the conveyances of which natural streams are a part of. The protection of natural streams was clarified and officially enacted in the early 1970s and has undergone some minor revisions over the years, including natural stream protections as a national resource. And with the criteria that we use to evaluate stream alterations, which are water rights, recreation use, natural stream environment, aquatic wildlife, and the ability to conduct high flows. Now, the bottom line, the state code that was enacted in the early 70s, 73-3-29, states except as provided in subsection 2, which talks about emergency actions. A state agency, county, city, corporation, or person may not relocate any natural stream channel or alter the beds and banks of any natural stream without first obtaining the written approval of the state engineer. Now, I mentioned the evaluation criteria. Here's the state code on the evaluation criteria. The state engineer shall approve the application unless the relocation or alteration. Now, here's a note. The state engineer shall approve unless there's an issue with these. So if they impair vested water rights, 2, unreasonably or unnecessarily adversely affect a public recreational use or the natural stream environment, 3, unreasonably or unnecessarily endanger aquatic wildlife, or 4, unreasonably and unnecessarily diminish the natural channel's ability to conduct high flows. Now, just want to make a note that most alterations I come in contact with are not perfect, but we really strive to minimize the impacts. That's imperative. Projects must be also appropriately justified, not just to play in the water, right? Now, violations, except as provided in subsection 2 that talks about the emergency authorizations. A person who knowingly or intentionally relocates a natural stream channel or alters the bed and banks of a natural stream channel without first obtaining the written approval of state engineer is guilty of the crime punishable under section 1727. The state engineer may issue an order for the repair and restoration of the bed and banks of a natural stream channel altered contrary to or without a permit issued for that purpose. There's also other legal actions that can be pursued. And even if the state engineer determines that we're not going to pursue a particular violation, it's still a violation, and other harmed parties may take civil action. Well, the application process, as stated in the code, is that an application to relocate or alter the channel shall be in writing with the following information: name and address, a complete and detailed statement of location and nature and type of alteration, the method of construction, the purposes, or like of the application, like I said, justification, and any additional information the state engineer considers that's needed. Supporting documentation usually includes, oops, let me go back. Usually includes the location map, photos, plan and cross-section views with surrounding features, pre and post construction changes, revegetation, mitigation plans, and channel dimensions, which also include bank-full, ordinary, high water, that's labeled. Consideration for these joint permits requires disclosing the length of the stream channel, length of fill, and or displaced material below ordinary high water. It is important to include justification of the project and how impacts are minimized. Also, it's been helpful when people include their email contact information. Things can get resolved a lot quicker when that happens. Now, here's just a quick example of something I just drew of a plan view and cross section. I get all types of plan views and cross sections, from rough sketches to fully developed engineered plans, and depending on the project, anywhere on that range may be acceptable, depending on where, how sensitive that project is or how important that project is. If it's a simple culvert, or to access farmland, it's not so critical. However, if it's a major transportation corridor, then we need engineered plans. So it just depends. Here is illustrated labeling and dimensions. So it's important to have the plan view, the bird's eye view, and then the fisheye view. One here is depicted. There's a cross-section view of a BDA, and also a cross-section view of riprap bank stabilization. I'm not the best artist, but it works if we can communicate and understand through these illustrations. Here's another one, kind of a 3D model that I put together a while ago. It's not fully labeled or with dimensions. So the stream alteration application, the one that's currently used, has been modified over the years, but was developed in the 1980s. The Corps and the state entered into an agreement to that for most stream alterations, they would also be authorized under the Clean Water Act. These are intended to be projects with minimal impacts. And this agreement is renewed or updated approximately every 5 years, and includes exclusions, limitations, and conditions for each specific state stream alteration permit. For any particular stream alteration permit, a joint permit application form with applicable supporting documentation is submitted with the appropriate fee and circulated for 20 days to the Corps and other agencies for comment. If the Corps issues a verification that the project or application qualifies under the Programmatic General Permit PGP 10, then an authorization approval letter is sent with conditions after evaluating the merits of the project compared to the state's approval criteria that I mentioned before and the comments received. Applications can also be rejected or withdrawn. However, we do like to work with the applicant to make an application better, or modify the project to make it justifiable. When the Corps determines that a project or application does not qualify under joint permitting, the state engineer may continue to process the application as a state-only decision. And then the Corps would work with the applicant to develop whatever additional plans or requirements are needed. Application processing is usually 1 to 2 months, with approval expiration being 2 years, or the expiration date would be the next PGB 10 agreement renewal date, whichever is less. Extensions are granted on a limited basis. And now the current expiration of the PGP 40 is this coming year, the 22nd of February, 2021. It is often preferred to submit applications with supporting documentation electronically by email or other method, although we still get a lot by mail. Although the application can be downloaded, it is not interactive. Application fees can be paid with check or in person with credit card. We do not have the capability to take credit cards over the phone or online yet. Application fees are $2,000 for commercial applicants, $500 for government applicants, and $100 for individual applicants that are non-commercial, non-government. Make sure that there's enough information on the check or attach the payment to match it with the application, so we don't get it confused with other applications or can't match it. Here is an example of the application form, the blank application form. This is the first page. There's some information here that's not necessarily needed. So like the project location, if you have a really good X marks the spot, that's actually preferable. We plug that into the database and it automatically populates this information, or we can access that population from that. Let's see. This is the second page. There's questions here, and just answer them to the best of your ability. If we need more information, more clarification, we can always ask for that. And then the fine print below here. Make sure you can answer those questions in a paragraph on each, or whatever's applicable. Now here's the third page of the application. You sign it so we know who's responsible, and any contact information that you may have. You can add the email here also. Oh, it has the filing instructions. There's the address. Depending on where it's at, there's two of us for the state, Chuck Williamson and myself. I'm over the West Desert, Davis County, the northern part of the state. The Uinta is the eastern part of the state down through Blanding, Moab, Blanding, Bluff. My colleague Chuck Williamson is the Salt Lake Valley, the I-15 corridor down through St. George and Escalante. Now, what constitutes an alteration? Projects that impact the bed and/or banks of a natural channel are considered alterations. Some impacts, such as skipping rocks, humor there, planting vegetation, and woody debris removal, are not considered significant enough to warrant permitting. The skipping rocks, I was thinking about, we've had some complaints about rocks being moved around in a stream, and we find out that it was somebody camping. The kids went and moved a few rocks to just playing in the stream. Those usually don't warrant permitting because the next high flow just rearranges the rocks to where it needs to be anyway. It really is not impactful. So it's a judgment call there. The Corps regulates waters of the U.S., and I guess Nicole is going to do a presentation tomorrow on this, so she can clarify anything that I may make a mistake on here. The Corps regulates waters of the U.S. such as streams below ordinary high water mark that are associated with navigable waters, wetlands, and large bodies of water such as lakes. The state regulates natural streams, including their bed and banks, twice the bankful width up to a maximum of 30 feet on either side of bankful. So we have overlapping jurisdictions there. So for the most part, most of these stream alterations can qualify under the joint permit program. Typical alterations are bridges, culverts, pipelines, paved trails, rehabilitation, bank stabilization, outfall structures, dredging, diversions, dams, dam removal, in-stream structures, and BDAs, what we're focusing on today, and many others. Now, here's a few photos. I love my job. I get out and it's just beautiful areas that I get to see. I just love Utah. This is Black's Fork. They were wanted to reconstruct this bridge that had been blown out. Here's something in Millville. The bridge didn't have enough capacity. They did build a new bridge just upstream a little bit. Culverts, of course, the weir, and of course BDAs. So yeah, there I am enjoying myself constructing these BDAs. Now, in regards to BDAs, the state engineer determined that there's some water rights implications for BDAs. Number one, that a stream alteration application is needed. Number two, the regional water rights engineer, we have several of them in the state. There's a couple of them in the Salt Lake office, and then Logan and Vernal and Cedar City, Richfield, Price. That those regional engineers need to determine for each project whether water rights are needed. It is assumed that BDA impacts would be stabilized within a short period of time and that a 1-year temporary water right change application would be sufficient. A temporary change application would not be needed for wildfire, or wildfire or similar events, catastrophic events. And 5, this policy doesn't preclude others from asserting damages pursued in court outside of what the Department of Natural Resources does. Seems like there's one more thing I was going to add to that. Can't remember. It'll come to me. So a water rights engineer may determine, well, oh yeah, that was one point I just wanted to emphasize, that BDAs, from my understanding, are built to be deformable, to be temporary, and there's a variety of different intents for constructing BDAs. Now, and those need to be explained in the permitting process, but it also has implications for whether water rights might be needed or not. Now, a regional engineer may determine that a water right might be needed. It could be a permanent water right, or they may say just a temporary one, as discussed, previously discussed, that good for 1 year. For small and now another response that I've had from a regional engineer, for small BDA structures that don't impound water above the natural banks of the stream, it is assumed that no water right will be needed. If the water impoundment exceeds the natural banks of the stream or irrigates lands not previously irrigated, a water right may be necessary. Stream alterations will reflect this decision by the regional engineer. You know, and another way to look at this is that if the BDA is built higher than bankful level, so that the water goes out onto the floodplain, that structure is built higher than the channel and may be considered an embankment, a dam, and would have to undergo a dam safety evaluation. And of course, there's a sensitivity about water having a beneficial use other than what's in the channel. So the state engineer kind of struck a balance here. It seems that seems to be working okay. Not that I'm going to read this, or not that you need to read this, but just know that this is the decision from the state engineer, Kent Jones, the 5th of December, 2018, that I just summarized previously. There's 2 pages of that. Now, what are the expectations for restoration, in particular with BDAs? Is there are varied applications of BDAs in restoration. It is important to detail expected results of implementation. It is also noted that BDAs are expected to be deformable and are temporary and do not function as a substitute for more permanent structures. I think that's important to note, that they're not going to perform like we expect a permanent structure to perform, therefore they'd be inadequate. But if you expect them to perform as a BDA, a temporary structure, a deformable structure, to cause a result that you want, I mean, then that would be justifiable. It could be to, I mean, there's a variety of things that you would need. You may want to raise the water table. You may want to accelerate or guide a more meandering stream if it's straightened. Anyway, a variety of results. One thing I wanted to go over is the website navigation. If you Google Utah Division of Water Rights, or here is the URL address, www.waterrights.utah.gov. Our website I think is pretty good. This website shows water rights information, dam safety information, stream alterations, well drilling, and other types of information. This is our home page, and on the upper left it has programs, and this shows the pop down showing the different types of information you can get. If you click on the stream alteration on this pop down, you get this page, and in the blue left hand side here you see you can go to a stream alteration database. There's application forms there. There's fact sheets that you can go to the Utah code. We have administrative rules that clarify the code. Like what do we consider bed and banks? Definition there. And banks, let me just mention that here. Banks we consider to be twice the bank full width, up to a maximum of 30 feet. And another handy tool there on that pop down, or that hot link list, is stream alteration maps. And you can find locations. It's interactive. You can find all kinds of information. And we'll go there in just a minute. So this is when we clicked on the application forms. So this is the application forms page, and that first hot link there, joint permit application, you click on that, you can download the joint permit application. Now, if you know that you're doing an individual or a nationwide permit with the Corps, and you're just doing a state only with us, you still fill out this joint permit application form, let our office know, me know, and we will process it as state only, and then the Corps can work with the applicant to do the individual or nationwide permits or whatever they need to do. There is, and this is when you click on, let's see, let me go back. This is when you click on Stream Alteration Database. You get this page. And so this, the left button over there, that's new actions. And anything that's being circulated that hasn't been processed yet. Then there's all actions, which include the new actions, all actions. They're sorted by year. In fact, this next page, when I click on all actions, you see this page. It brings up the current year and everything's sorted by chronological order as we receive them by region. So the 20 on each of those numbers is for the year. The middle number is the hydrologic region, and then chronologically in each region. The buttons across the top, those are ways to sort that list, basically. Okay. Now, oh, yes. So if you go down to Stream Alteration Map, you'll get a blow up of the state, and you can zoom in, and I'm zoomed up here to Jeremy Ranch Road, I guess. And depending, you can click off to, there's layers and base maps and other tools, and you can click on each one of those and get information, or on the tools, you can place a flag and get a location. You can crop it and use it as your own location map. So yeah, this is, instead of an aerial, this is the topo map, the flag that I put in there for, who knows what potential alteration. Existing alteration permits, you can click on one, it brings up additional information and a hot link to actually go back to the database for all the documentation. Here is zoomed back out, give you an idea where in the state it is. Anyway, I guess that brings us to the end. Let's see, questions. Let me stop sharing. Is that what I need to do, Sarah?
You're fine to leave it on this page if you'd like.
Oh, okay.
Thank you so much, Daren. We really appreciate your expertise. We have a number of questions here, so I'll just go through them in the order that they were asked. So the first question we have is, when you say natural streams, does this mean all streams, including ephemeral?
Oh, that's something I should have put in there. So yeah, our state code and our the rule that clarifies the code states something like this, that a natural stream is considered any waterway that receives enough flow during the year that it would support an ecosystem that's different than the upland. And for the most part, we look at riparian vegetation. So it's not exclusively riparian, but that's primarily what we look at. So, for example, if you have an ephemeral channel that has sagebrush and rabbitbrush going down into the channel here and there, it obviously is not getting enough water, and we would not require a permit on those. In the past, we've considered those in the gray area a little bit. If the Corps and us decided that was okay to do a joint permit on those, we would process a permit on those, but as a joint permit, but we would we would not require that on those type of streams. Say it's Moab Wash, where it's scoured, completely scoured. There is no vegetation at all, not even the upland type of vegetation. But it interfaces with infrastructure, culverts and bridges and roads and things like that. It does have an ecosystem different than the upland. And we've determined that on some of those, if they're sensitive enough, we will require permitting on those. But for the most part, we wouldn't. So primarily we're looking for, if we see on a stream system, riparian vegetation, willows, cottonwood, water-loving plants, wetland plants. If we look at a map and it's on an aerial and it's obviously much lusher, you pick that out on an aerial map where it's lush vegetation, then it probably needs a permit. Does that answer that question?
Yeah, that's perfect. Thank you. Our next question is, does the joint permit cover the Section 401 water quality certification, or is that separate?
Yes, when our agreement with the Corps is up for review every 5 or so years, the Division of Water Quality weighs in on that and issues a letter of certification, and so for all joint permit applications. So basically, yes, that does cover that.
Perfect. And then our next question is, what if an actual beaver adds to a BDA and makes it a bigger dam that is above OHW? Is the agency or people who got the original SAP for the BDA work responsible for dam safety and or obtaining a water right?
Well, yeah, that's a good question, and I don't know what the definitive answer to that would be, since this is all kind of new. I don't know how that would fall out if it were challenged. I would, whatever, this would be my gut instinct that whatever beavers do, they do, and we're not going to prosecute the beavers. Now, I don't think that there would be any fallout from whatever the beavers do, even if we entice them to do it. I think, maybe that would be for a judge eventually to determine, but I just don't see it.
Okay, perfect. Thank you. And our next question is, are multiple SAPs needed for a project that has multiple BDAs on the same stream?
Okay, so I evaluate stream alterations on a stream system basis. So if there are multiple alterations on one stream, it just requires one application. If you're doing, say, BDAs on 2 or 3 or 4 different streams, separate streams, then I would need an application for each of those streams. Now, that being said, if this is processed under a joint permit application, there are limitations to that agreement. One would be length of impacts. If the length of impact exceeded 300 linear feet or 500 linear feet for ephemeral channels, and then there's a restoration component. I'd have to look at that and read that exactly. But there is a limit of stream length that you can do. Otherwise, if you exceed that, then there would need to be separate permitting from the Corps, and especially if there might be wetlands impacts too. So then the Corps, that would also kick that out to the Corps for a separate permitting.
Okay, wonderful. And then our next question is, I have a road improvement project that will alter several streams. Will the one permit cover all actions?
Could you repeat that again?
Yes, I have a road improvement project that will alter several streams. Will the one permit cover all actions?
No, if they're separate streams, it has to be separate permits. Now, just a clarification on that, if I'm following say it's the Colorado River and you're doing road improvements on the Colorado River or any river, and there's tributaries coming into that main stream, if you're within 1,000 feet, quarter mile of the confluence with that main stream, I would consider one permit. But if it's clearly beyond the confluence and up the channel a ways, it may need separate permitting.
Perfect. And then we have a couple questions in the chat. So the first is, can Daren please talk about how the Utah regional engineers have approached determining the natural bank when the stream is deeply incised and the BDA project is to reconnect the stream to its former floodplain?
Huh. I don't know that I've thought about that problem or talked with anybody about that problem, but I think that I would look at it from the point of view of what is existing. So you try to determine what the bankful is for the existing structure. Yeah, that's an interesting question, because you're trying to raise the bankful elevation. You're trying to raise the ordinary water up, but and maybe that would be on a case-by-case basis. I'd have to look at it, but I would tend to look at the existing conditions and regulate according to the existing conditions, and not necessarily historic or potential. I don't know. That's an interesting question.
Yeah, thank you. And then our next question is, so are state-only permits for streams that are not WOTUS, but are state natural streams? Could you please elaborate on this aspect when COE determines that a joint permit isn't appropriate, but then the state issues a state-only permit?
Okay, let me see if I understand that. Does that state that the Corps says that they're not requiring a permit?
Let's see, determines that a joint permit isn't appropriate.
Okay.
Looks like.
So, okay. Basically, we use the same application, the joint permit application, whether or not it's determined before the application was submitted or during the process, that if the Corps needs separate permitting or if the joint permit application is not appropriate or processed as a joint permit application, then we just go ahead and approve it or process it as state only. There's really no difference in the processing except some of the conditions are different. The expiration date may change. I don't know if I'm answering this question right. Yeah, does that answer that question? I'm not sure I answered that question.
Well, he has a follow-up, so let me just read that. He says, could Daren give an example of when this has occurred? Just trying to understand a case where a COE permit is not needed, but a state permit is.
Oh, well, I can give you a couple of instances where that's the case. For instance, the Corps of Engineers jurisdiction are wetlands and lakes and large bodies of water, but for streams, it's below ordinary high water. Now, the state's jurisdiction are bed and banks being up on the bank, above ordinary high water. So say you're putting in an outfall structure that just extends to the top of bank, or you're placing a trail, a paved trail or other structure that is above ordinary high water, that would require a state permit, but would not there wouldn't be a joint permit requirement for that, or a core requirement for that. Dredging would be another instance of that, where if you were removing fill completely, then because the Corps' requirements, and Nicole may elaborate on this tomorrow, because the Corps regulates fill, which if you're placing something in the stream, it can be native, it can be rocks, it can be sediment, it can be man-made, like a culvert or something. If you're placing that in below ordinary high water, that requires permitting from the Corps, which can be also through the joint permit process. However, dredging, if you're removing that, like with a backhoe bucket, and carefully removing it to an upstream site, then there's no fill placed or displaced. As opposed to, say, you put a D9 cat, and I don't know if this is in any coded or not, but knowing project managers over the years, a D9 cat would push sediment from one position in the channel to another position in the channel and to another position until it finally gets out of the channel. But that fill has been displaced and is disturbing the channel in multiple places. So that's not carefully removing the fill. So I'm making a distinction there because it's important to know how you remove that fill dredging. So if all you're doing is dredging and carefully removing that to an upland site, all you need is state only. Those are some types of state only permits where a Corps engineer's permit is not needed. Also, there are times when the joint permit is not, your project doesn't qualify for that, such as if you exceed the length limitations. If the project is lengthy, over 300 or 500 or 750, depending on what category you're in, or if you're working on tribal lands, or if there's impacts to threatened and endangered species or impacts to cultural resources, those things do not qualify for the joint permit. So we would have to do separate permitting in those cases. I don't know, I hope that answers that.
Yes, thank you. And we are almost out of time, but we have one more question from Rhett that says, could the 401 water quality requirement and the state's ability to comment on stream projects be undermined by Executive Order 13868, promoting energy infrastructure and economic growth?
Yeah, I'm not acquainted with that. I don't know. I'll have to look at that. I mean, anytime there's an executive order, sometimes those are not vetted completely, and sometimes there are conflicts when say there's a court decision or executive order, or maybe even legislation that wasn't fully thought out. Sometimes there are conflicts. I would love to take a look at that and see if there's any conflicts.
Yeah, I'll make sure to take your name, Rhett, and we'll reach out to you with more information on that. But we are out of time. Thank you again so much for being with us, Daren, and for everyone who's joined us. We really appreciate you.
You're welcome.
Yeah. And this will be recorded and put on our website this week. So if folks need to check back in, all this will be up. So thanks again, and I hope you have a wonderful week.
Wonderful. You too.
Thank you.
Thanks, everyone.
Bye.
Bye.